Abusuan breaking news. Breaking news a eba ne say Chief Justice Torkono okopiem ewo Supreme Court as akofale stopping the vetting process and the swearing in of the new Chief Justice Baffoe Boni. Yankoni from Joy News credit somomo Chief Justice Torkono a day file to stop the vetting process and the swearing in of the new appointee of a Chief Justice position on a Lordship Justice Baffoe Boni. Then going to go to more details.
High Court seeking to halt the vetting and appointment of Baffoe Boni as a new Chief Justice. She's asking the court for several reliefs, challenging both the legality and the grounds for her removal from office as head of the Supreme Court of Ghana. Well, let's delve into this. Joining me in the studio now is member of our legal affairs desk here at Joy News, Kweku Asante, joining me just to break down this. Kweku, you've been going through it. Quite a lengthy one, 278 pages. Let's try to do justice some of the key concerns she's raising in this suit.
So let's start first by talking about the reliefs by way of judicial review that Madame Torkono is seeking. And just by way of recap, the Chief Justice, in fact, the former Chief Justice, Gertrude Torkono, has been removed from office for some months now because the Poorman Committee that looked into the matters decided that for some reasons there was stated misbehavior on her part, for which reason she could no longer remain in office as Chief Justice. Mind you, Article 146 says the President is bound by the recommendations of the committee. So the President really did not have a choice in this matter but to comply with the recommendations of the Justice Poorman Committee and remove her from office. And so by a warrant signed by the President, Madame Gertrude Torkono was removed from office as Chief Justice and has since then not been serving. And we know that Justice Baffoe Boni has since been nominated as the next Chief Justice. And with Parliament set to resume next week, it is very likely he will be vetted within the next 2 weeks. So let's get into some of the actions. And this is the first legal action that Madame Gertrude Torkono is filing, that is fighting frontally the findings of the committee. And so she's asking for three main reliefs that goes to the work that Justice Poorman's committee did, and then another that goes to what Parliament may decide to do in the future. One, she's asking for an order of certiorari, that is an order of a court that quashes the decisions of a lower court or an administrative body for the purpose of being quashed. The proceedings of 15th of May and the entire proceedings and outcomes of the Article 146 committee set up to consider petitions to remove the applicant chaired by Justice Poorman. In plain English, Madame Gertrude Torkono is asking the High Court to, by an order of certiorari, quash everything that Justice Poorman Committee did. And that five-member committee, including the former Auditor General, all the work they did, Madame Torkono is asking that all of that be quashed. Two, she's asking for an order of certiorari for the purpose of being quashed and for quashing each and all of the three grounds given by the Poorman Committee for recommending the removal from office as Chief Justice. The Chief Justice was removed on the basis of certain three grounds that were found by the committee. And the Secretary to the President wrote to Madame Torkono saying that she has been removed from office by virtue of those three grounds. This suit that has been filed by the Chief Justice says those three grounds must also be quashed. The third one is an order of certiorari quashing the warrant by the President dated September 1, 2025, removing her as Chief Justice from office. And so she wants, consequently, the removal of the Chief Justice to be also quashed. And then the fourth one, an order prohibiting the consideration and appointment of a new substantive Chief Justice of Ghana. That means the nomination that we know now will go to the Parliament of Ghana for Mr. Baffoe Boni, the acting Chief Justice, to be vetted, and if approved, to assume office as Chief Justice. Madame Torkono is saying that that process must all be put on hold. In fact, it must be suspended, it must be quashed, because it doesn't have any legal basis and any orders. Then now let's get into the grounds that the Chief Justice, the former Chief Justice, I keep saying Chief Justice, is canvassing for this new action that she has, through lawyers, Edukusi, filed in court. She says that all the alleged findings and grounds for recommending that she be removed do not meet, and I quote, even remotely, the standard of stated misconduct, incompetence, or infirmity on ground of inability to perform the functions of office imposed by Article 146. That is one ground. And that the finding and recommendations of the Justice Poorman Committee violate, and it says blatantly violate, relevant provisions of the 1992 Constitution. Third, the first alleged finding and recommendation of the Poorman Committee is false, misleading, irrational, and unreasonable and illegal on account of purporting to find, quote, misconduct of the Chief Justice for expenditure that has not been disallowed against the Chief Justice, nor the Chief Justice surcharged for aid by the Auditor General in the audited accounts of the judiciary. Then, again says, the first alleged finding and recommendation of the Poorman Committee is false, misleading, irrational, unreasonable, and unfair on account of purporting to find stated misconduct. Then, 5, the first alleged finding and recommendation of the removal is again unfair, unreasonable, illogical, irrational, perverse, and absurd, and therefore unconstitutional and illegal on account of purporting to find misconduct on the part of the Chief Justice when the legitimate expenses on the Chief Justice vacation were administered and authorized by the Judicial Secretary, the Director of Finance, and other people that she mentions in this section. And then goes ahead to say that the issues that have been raised by the Poorman Committee, and specifically, let me quote this part, is very interesting. She says, the finding and recommendations of the said committee constitute an abuse of power and therefore unfair and illegal, and breach the legitimate expectation raised in the applicants by the terms of the appointment of as Chief Justice of the Republic by the travel policy. Then she goes to the second finding. It says that the second finding constitutes an abuse of power given to the committee and is unfair, unreasonable, perverse, and absurd because she says she's allowed to transfer judges and other officials of the judicial service. Then the third finding is breaches the exercise of the legitimate obligation placed on the applicant by Article 1254 as head of administration and supervision of the judicial service. It goes on and on to say that the 3 alleged findings and recommendations for removing the Chief Justice from office by the Poorman Committee are false, misleading, irrational, absurd, and perverse in the Wednesbury sense. The entire findings and grounds of the said Poorman Committee for removing the Chief Justice from office are in violation of the applicant's constitutional rights contained in Articles 19.3 and 23 of the Constitution, and that the proceedings of the committee violated Articles 23, 296, 146.3, 146.7, 281, and 295 of the Constitution, and therefore illegal, void, and of no effect, having been conducted in breach of the rules of natural justice and as adversarial proceedings under Article 146. And then finally, that the entire proceedings of the said committee were conducted with substantive and fundamental procedural irregularities and unfairness that renders the findings and recommendations a nullity. So Faustina, Madame Torkono is in court, and ultimately her case is that the principle and the issues that were raised ultimately by the Justice Poorman Committee that led to her removal from office, national unconstitutional, they breach the Constitution and therefore must be set aside. And if they are set aside, she wants 3 things: that Justice Baffoe should not be considered and appointed as Chief Justice. Ultimately, she should be reinstated as Chief Justice, Faustina.
Thank you so much, Kweku. And this document is quite lengthy, 278. That's how long it is. And so we'll be delving into it. We'll be reaching out to counsel for the former Chief Justice here on The Pulse. But it's a good time to bring in Kweku Ansah-Asare, former director of the Ghana School of Law. We appreciate your time here on The Pulse. You've just been looking through this document, quite lengthy, but let's look at some of the concerns she's raising. She's raising concerns about Justice Poorman's committee and the grounds for which they declared that she was involved in that, quote, stated misbehavior. She uses quite strong words that the report is false, misleading, unfair, unreasonable, perverse, Quite strong words to describe a report, and it raises a lot of questions. But from where you sit, let me take your initial reaction to this report.
Thank you very much. My initial reaction she's
to this suit she's filed.
To tell Ghanaians that at the time she was appointed by former President Nana Akufo-Addo, former that to Torkono not for purpose. She is displaying a lot of emotional imbalance and immaturity. She has to realize that the seat of the Chief Justice is not a traditional stool that the occupant can claim as a right. My initial reaction. But more on, the legal terrain. What doing is merely seeking to re-argue, rehash, a case that she fought fiercely before the former committee. Now that the former committee has submitted its report and the president has accepted the report and the recommendations contained in it, there seems to be former findings. They now become the decision of the president. And the decision of the president was taken in accordance with the Constitution. It cannot be questioned. Nowhere in Article 146, clauses 1 to 11, that give a right to question the president's acceptance of the recommendation. So, period. That must be the end of the case.
That is not the end of the case, is it?
Activate the process.
That is not the end of the case, really, because she's concerned
that must be the end. She should be told that she has come to the end of the road.
So she's raising concerns that even the recommendation that the committee gave, their findings was flawed, and that flawed findings is what the president acted upon. So she wants the whole decision of that committee to be squashed by the court.
Is merely reactivating, something that cannot be reactivated. The case is dead and buried, and nothing she does will make the dead case turn in its grave. I'm sorry to, make this observation, but a former Chief Justice must understand that she's bound by the Constitution. If he does not appreciate the EJ removal process, if she cannot observe it, she cannot respect it, she's only demonstrating that when she was appointed, she was immature. And because she was immature, she's, suffering all this. She has to stop. She has to stop. Now, the grounds are frivolous. The entire action is vexatious and frivolous. She must know that in law, there is something called res judicata, and she's caught by res judicata. She cannot resurrect, the case. The president, has acted within the confines of the Constitution. What he is trying to do is purporting to prevent or prohibit the president from discharging his constitutional obligations and duties. The nomination of a CJ is not a presidential privilege. It is a constitutional duty, a constitutional obligation that must be performed. The vetting process is a constitutional duty. It is an obligation. It is not a right or a privilege of the Speaker to convene Parliament for the sole purpose of vetting the President's nominee, for consideration as Chief Justice of the Republic of Ghana. And therefore, her latest action is flawed. it will not go anywhere.
But then here's the concern, really. Should she go to court and the court finds that some of the concerns she has raised, especially about the committee's report, and then we have a situation where we have already vetted and approved a new Chief Justice, what then will play out in that scenario, really?
But what is it, in the Constitution that after the president has accepted and acted upon the recommendations of a committee established pursuant as the one for the state, any court, can assume jurisdiction to rehear the matter. Nowhere. This latest action, is again dead on arrival. I mean, nowhere. No, the court will have jurisdiction to entertain, this frivolous and vexatious application.
So even when she has filed the suit at the High Court, they lack jurisdiction to hear this matter? Is that the...
This is a pure and simple Article 146 CJ removal process. The tagging of Article is discretionary thing that, one can fall on the post spelled out by the Supreme Court in the Awuni and West African Examinations Council case. Sorry to make this observation. But again, I mean, it is only showing our lack of understanding of, the provisions enshrined in Article 146. And for a whole Chief Justice to display this ignorance, the nuances of Article 146, it's mind-boggling. I'm sorry that I'm being too severe on the CJ, but I think that, what she's doing, is creating a caricature of herself. And she must be told in plain language that the office of CJ is not a personal property. And therefore, she cannot stop the president from proceeding to perform or discharge. Indeed, if the president, fails to discharge or perform his constitutional duty by virtue of Article 144, Clause 4, he, the president, will rather be in breach of, the oath he subscribed to the good people of Ghana. And that can be an impeachable offense for not enforcing, the Constitution or, observing, the Constitution, that integrant of the oath. That is subscribed. But
Mr. Asasari, the Article 146 is clear, really, that you must be able to establish, quote, stated misbehavior. And that's the whole argument of the former Chief Justice. She argues that she never indulged in anything that would have warranted that, quote, stated misbehavior for which the committee recommended her removal. So even though the nuances of Article 146 exist, there are concerns that an injustice may be
accepted the recommendation. Whatever she does now is only, making ugly noises, which will constitute a social nuisance. That will be the effect. Complete social nuisance and a mess, of, her legal prowess.
Thank you so much, Likee Tv Be.